You may be seated. Well, let's do that. Would wonder if you come over and move this flag over some. Seriously, just move it over to the corner, and move this one over to the corner, please. Oh, don't do that. Just slide it. Just slide it. We always wanted the presentation of the colors. I don't know. Is that in the corner on the floor? Okay, okay.
He's moving it over.
That's too far. We want it back up here. Mr. DePippa, please put it right up in the corner, okay?
Which corner?
All right, it's time for a Mountain Dew. All right, what in the world are you doing?
He's matching the other side. That works.
That's all right. We'll, please note that council has screwed up the flags.
Can we be clear about which council?
You'll have your chance in a minute, okay? That's it. Okay. This hearing, I can't even talk now. This hearing will come to order before the commission today as docket number 26009-U, which is styled in the matter of an investigation of the sale of Energy Arkansas LLC's nuclear production tax credits and a determination of the treatment of all other tax credits. This hearing was scheduled by order number 4 in this docket on March the 3rd, 2026. Please silence your cell phones. If you need to make a call, be sure and go out in the hall and do so. For the record, will the attorneys state their appearances and the names of those persons they intend to call as witnesses? Ms. Law.
Good morning, Jana Law for Entergy Arkansas, and I have Cesar Caballero with me, and we have two witnesses today, Jay Lewis and Stacy Whaley.
Thank you. Mr. DePippa, please introduce yourself.
Joel DePippa with the Arkansas Advanced Energy Association. We have no witnesses to present.
Thank you, Mr. DePippa. Mr. A.G.
Michael Coots with the Attorney General's office. We have no witnesses.
Thank you. Staff.
Miles Sparks, Attorney General Staff, the Arkansas Public Service Commission. I have with me today Wes Newman, Slade Mason, our witness, Jeff Phillips.
Thank you, sir. Will all witnesses who plan on testifying please stand and raise their right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Finally, opening statements shall be limited to a maximum of 10 minutes for each party. If you do not have a witness, you will not be permitted to offer an opening statement or cross-examination. Mr. Caballero, you may make an opening statement. Or Ms. Law, thank you.
Good morning, Chairman Webb, Commissioner Tate, and Commissioner Anderson. Entergy Arkansas is pleased to appear before you today to present a balanced approach to flowing through to customers the benefits of production tax credits from its nuclear assets, Walnut Bend, West Memphis, and Driver Solar. The Inflation Reduction Act provides PTCs for power generated from nuclear and renewable energy resources, and the benefits of both result from the monetization of the PTCs or utilization of the PTCs to reduce federal income tax liability. Both types can be monetized through a transfer to a third party to ensure that the net cash value is realized regardless of a utility's current tax position. Fundamentally, though, there are two key differences between solar and nuclear PTCs, which is why EAL has proposed separate approaches for each. Those two differences are the calculation of the PTCs and the status of IRS guidance for the nuclear PTCs. For the first difference, solar PTCs are calculated fairly simply by multiplying the statutory per kWh solar tax credit amount by the amount of solar generation of a qualified facility. Conversely, the calculation of nuclear PTCs is more complicated and less certain, because it requires an additional step that potentially reduces the value of the credit on the gross receipts of the nuclear unit. In EAL's case, the gross receipts are determined by capacity prices and locational marginal prices, or LMPs, that are variable. Because a nuclear generating facility's annual gross receipts can vary dramatically each year depending on generation, capacity prices, and LMPs, the amount of nuclear PTCs EAL is able to claim for each unit could also fluctuate dramatically and even be reduced to zero. The second difference relates to the status of IRS guidance for the nuclear PTCs. While the calculation of PTCs for solar resources is now well established, the calculation of nuclear PTCs is uncertain due to the lack of IRS guidance. The final IRS determination regarding the method of calculating gross receipts for the reduction amount could result in a number of outcomes, up to and including a determination that EAL's nuclear generation does not qualify for any nuclear PTCs. Absent formal IRS guidance to all taxpayers clarifying the calculation, EAL does not expect a final IRS determination regarding the amount of its nuclear PTCs until 2030. EAL has monetized the 2024 PTCs generated from its nuclear facilities and Walnut Bend, West Memphis, and Driver Solar by selling the PTCs to third parties. This provides for the immediate realization of value for the PTCs, the benefits of which can then be provided to customers. By contrast, utilization depends on Entergy's consolidated federal tax income liability. This can result in no realization of value until there is a tax liability to offset, which may not materialize for years, thereby deferring the potential for customer benefits. When determining whether to monetize or utilize credits, a taxpayer must also consider that current tax rules only allow for the sale of PTCs generated in a given year prior to the filing of the tax return for that year. Thus, if the 2024 PTCs had not been sold prior to October 25, they would no longer be eligible to sell. Unforeseen future events, such as storm losses or tax law changes, could further reduce the value of the PTCs for customers by deferring the utilization of such credits, if EAL had elected not to monetize the 2024 PTCs. EAL respectfully submits that these facts support that the decision to monetize the PTCs was prudent, instead of waiting for their potential future utilization on a federal tax return. Importantly, whether nuclear PTCs are monetized or utilized, providing benefits to customers from nuclear PTCs that are claimed prior to the issuance of clear formal guidance from the IRS does not create or alter the risk that such benefits might ultimately not be allowed by the IRS and thus need to be recovered. Accordingly, for nuclear PTCs, EAL is proposing the Nuclear Production Tax Credit Rider, NPTC, which would allow EAL to begin providing customers immediate benefits in the form of a full weighted average cost of capital return on the net proceeds of the monetized nuclear PTCs. Because the timing and determination from the IRS is uncertain, the nuclear PTC contracts require EAL as the seller to indemnify and make whole the purchaser if the PTCs are either disallowed in part or in whole. Accordingly, the NPTC rider also provides that if there is an unfavorable IRS determination, EAL would collect from customers the corresponding indemnity and other contractually owed cost. EAL submits that this provision is fair and reasonable because prior to the IRS's determination, customers will receive a full WAC return on the net proceeds of the PTC sale, equivalent to all of the benefits of the transaction. Without such a provision, there would be no incentive for owners of generation facilities to try to optimize the value of available tax credits by selling them where such sales are expected to yield a greater value on a net present value basis than utilizing them on the income tax return, as is the case here. Even if the nuclear PTCs had been utilized to offset the federal income tax liability, the same risk that the IRS could ultimately disallow some or all of the value would exist. If the IRS determination is favorable, NPTC provides that EAL would make a filing to begin flowing the net proceeds from the sale of the PTCs to customers. This approach ensures that the Commission will have the relevant material facts necessary to determine the appropriate amortization period. Setting the right amortization requires material facts not currently available, including the number of years that EAL will have monetized nuclear PTCs, as well as their ultimate value. If the amount of nuclear PTCs allowed by the IRS is quite substantial, which could occur if the IRS determination occurs after many years of monetizing the PTCs, then a rapid amortization period could introduce substantial volatility into customer bills. Additionally, prematurely determining the amortization period could present financial challenges for EAL, such as significant impacts on credit metrics and the need to secure significant and costly external funding, none of which would be beneficial to customers. Further, these possible negative impacts can have unintended consequences on rates that should be fully vetted in a future proceeding when the facts are fully known and can be examined holistically. With respect to the PTCs from Walnut Bend, EAL and staff are in agreement that flowing the PTCs through the formula rate plan is reasonable and appropriate. Further, the 30-year amortization period for the Walnut Bend PTCs was already established in docket 20052U. EAL has proposed to begin flowing these benefits to customers through Rider FRP beginning January 1st, 2027. For the PTCs from Driver and West Memphis Solar, EAL has proposed to treat them similarly to Walnut Bend with a 30-year amortization period and to provide the benefits to customers through Rider FRP. Use of Rider FRP appropriately matches the cost of the resources and the benefits of the PTCs in the same mechanism. For the PTCs generated by West Memphis and Driver, staff proposes to limit their amortization period to 15 years and to utilize a separate rider mechanism to flow through the benefits to customers. There is no conceptual basis to provide a different treatment for solar PTCs for West Memphis and Driver than for Walnut Bend. The cost of these resources are currently being recovered through Rider FRP, and it would be inconsistent to provide the solar PTC benefits of these resources through a separate rider. Notably, Mr. Hilton's position is also contrary to the basic principles of the MBSA, to which the Commission has required all utilities to adhere. This is because the solar PTCs at issue here were created to be a source of funding for renewable assets, and therefore Mr. Hilton's suggestion stands in stark contrast to staff's long-standing argument over the fungibility of capital and consistency with the framework of MBSA by arbitrarily removing one source of capital from the mechanism where the asset costs are currently being recovered. Simply, there is no evidentiary support to treat these two resources differently from Walnut Bend. EAL submits that its proposals are supported by the evidence and provide a balanced approach to providing benefits to customers. EAL has Mr. Jay Lewis and Ms. Stacy Whaley available today to answer any questions that you may have.
Thank you, Ms. Land. Mr. Parks? Mr. Park, be sure and pull that mic down to where you are speaking directly into it. There you go.
All right.
Thank you.
Good morning, Chairman Webb, Commissioner Anderson, Commissioner Tate. Appreciate this opportunity to present staff's case. As background for why this investigation docket was open, we must go back to two prior commission orders. First, in commission order number 15, docket 20052U, issued on July 13th, 2023, while discussing the treatment of federal production tax credits, the Commission stated that prior to an election of either investment tax credits or production tax credits by EAL for its eligible resources, the Commission expected a full vetting and approval prior to such election. The Commission's expectations was that such an election would result in an offset to rates or ratepayer credits. This Commission learned of EAL's monetization of the retail portion of its nuclear PTCs through EAL and other energy services operating companies' Federal Energy Regulatory Commission filings requesting approval of the sale of the wholesale portion of the nuclear PTCs for 2025. Second, in Commission Order Number 11 in docket 25055P, the Commission responded to EAL's petition for rehearing for clarification of Order Number 9 and addressed EAL's specific rate-making treatment request for the Cypress Solar ITCs. The Commission approved flowing the benefits of the Cypress Solar ITCs through the formula rate plan rider over a 30-year amortization period, but the Commission explicitly stated that its decision was not precedent for the treatment of all other PTCs and ITCs. So this docket was opened by the Commission to investigate the sale of EAL's nuclear PTCs for 2025, including the reasonableness of the terms and conditions of the sale, to investigate the appropriate rate-making treatment of ITCs and PTCs for all of EAL's eligible resources, determine how the proceeds of any sales would flow back to EAL's ratepayers, including the mechanism and amortization period, and for any other related matters. Specifically, we are looking at the monetized proceeds for the 2024 nuclear PTCs generated by Arkansas Nuclear One, as well as the solar PTCs generated by the Walnut Bend, West Memphis, and Driver solar facilities. While staff generally supports the company's proactive decision to monetize these tax credits to secure immediate cash value, staff has significant concerns with how EAL proposes to allocate the risks and benefits of these proceeds between its shareholders and Arkansas ratepayers. I will begin with the nuclear production tax credits. As we know, EAL made the decision to sell its 2024 nuclear PTCs to third parties at a discount in October of 2025. As ordered by the Commission, EAL currently holds those net proceeds and is accruing a return on them at its weighted average cost of capital, currently 6.75%, which is above the customer deposit rate of 3.05%. EAL's proposed nuclear production tax credit rider, or NPTC rider, is designed to provide cost of capital benefits of nuclear PTCs to ratepayers until the IRS issues a determination as to their allowance and finalizes the value of these credits. However, Section 74.4 of EAL's proposed tariff is fundamentally unbalanced. Because the IRS has not yet issued formal guidance on calculating nuclear PTCs, there is a real risk that the IRS could disallow some or all of the credits EAL claimed and sold. If that happens, EAL is contractually obligated to indemnify the third-party purchasers, which means returning the principal, covering the discount that buyers originally took, and paying any IRS interest and taxes. EAL's NPTC rider proposes that ratepayers bear 100% of these costs related to IRS disallowance. Furthermore, EAL is asking that ratepayers pay the company a carrying charge at the company's full weighted average cost of capital on the unamortized regulatory asset balance in account 182.3, which includes additional taxes, interest, and indemnification costs. EAL attempts to justify assigning a 100% of the indemnification responsibility to ratepayers by arguing that because EAL is paying interest on the net proceeds it is holding now, ratepayers should bear the entirety of the risk. Staff firmly rejects this logic. Let's look at the reality of the situation. In effect, ratepayers are loaning the principal amount of the monetized PTCs to EAL in exchange for interest. However, of the loan is unknown and the rate is insufficient to reward ratepayers for shouldering 100% of the indemnification risk. While awaiting the IRS audit, EAL has full use of the net proceeds to fund its operations without having to access external capital markets. This is a massive tangible benefit to the company. Meanwhile, the monetization discount that EAL accepted when it sold the credits was deducted on the front end. Ratepayers are not receiving a weighted average cost or capital, the WACC, W-A-C-C, return on the discounted amount. Yet if the IRS disallows the credits, EAL expects ratepayers to fully reimburse the buyers for that exact discount plus taxes plus interest and pay EAL a carrying charge on top of it. EAL's proposal is not fair and balanced, is not a fair and balanced sharing of risk between shareholders and ratepayers. Staff recommends 3 critical modifications to the MPTC rider to protect ratepayers. First, ratepayers' share of any indemnification taxes and other related costs resulting from an IRS disallowance must be strictly capped at 80%. Although staff submits that a commission finding that a full share of a 50-50 split of the additional costs would not be unreasonable. Second, staff recommends entirely excluding any carrying charges for the benefit of the company in the event of an IRS disallowance. If EAL truly believes monetizing these credits was prudent, it must be willing to shoulder a reasonable fraction of the risk rather than demanding guaranteed 100% risk-free recovery from its ratepayers. Third, we must address how the principal of these proceeds will be returned if the IRS approves the tax credits. Curiously, EAL's tariff precisely defines the timelines for charging ratepayers in a worst-case scenario, but completely defers setting aside a timeline for returning the actual principal to ratepayers in a best-case scenario. EAL argues that defining the amortization period now is premature and that we should wait until the 2030 audit concludes. Staff believes the timely return of the principal to ratepayers should be part of the consideration of all the costs and benefits related to the nuclear PTCs rather than be deferred and considered in isolation at some future period. EAL has already modeled the net present value of these outcomes. We recommend modifying the tariff now to guarantee that EAL will immediately begin returning both principal and interest to ratepayers over no more than a 2-year period following a favorable IRS finding. Ratepayers deserve the assurance that these proceeds will be returned in a timely manner. In addition, the MPTC rider discussed the monetization of the 2024 nuclear PTCs with the assumption that future years will be treated in the same manner. However, given the estimated conclusion of the IRS audit in 2030, it is unclear the rate-making treatment of subsequent nuclear PTs. It is unclear why the rate-making treatment of subsequent nuclear PTCs would not be affected. For example, if in 2030 the IRS concludes its audit of tax year 2024 and allows the monetized nuclear PTCs, shouldn't the remaining nuclear PTCs begin being returned to ratepayers immediately, providing both principal and interest? To ensure complete transparency, staff also recommends that EAL be required to file detailed work papers and journal entries with its annual rider NPTC updates, showing the exact amounts received, the calculations supporting the credits or charges by class, and any true-ups. Any additional information required can be provided through discovery. Now I will turn to the solar production tax credits associated with Walnut Bend, West Memphis, and the Drivers Solar facilities. EAL sold the 2024 PTCs for these facilities and proposes to amortize the expected proceeds over 30 years, the useful life of the assets, and flow them through the formula rate plan rider, or rider FRP, as was approved for Walnut Bend Solar Facility. Staff agrees with EAL's proposal for Walnut Bend solely because it aligns with a specific settlement approved by this commission in docket number 20052U. However, As the Commission explicitly stated in Order Number 15 of that docket, the 30-year amortization approved for Walnut Bryn was narrowly tailored to the unique facts and absolutely not precedential for any other resource. Therefore, staff firmly rejects EAL's attempt to blanket West Memphis and Driver Solar with this same 30-year amortization through the Router FRP. For West Memphis and Driver, staff recommends returning these benefits through a separate rider, similar to the NPTC rider, over an amortization period of no more than 15 years. Why 15 years? These solar PTCs are generated over the first 10 years of a facility's operation. Under normal utilization, ratepayers would see the full benefits within a decade. With monetization, EAL receives the cash proceeds even faster, stretching the return of these immediate cash benefits over 3 decades unnecessarily deprives today's ratepayers of the value they are funding. EAL claims that a shorter amortization period creates intergenerational inequity because future ratepayers paying for the plant won't receive the PTC benefits. Staff disagrees. In the early years of a plant's life, the net plant cost and therefore the revenue requirement burden on current ratepayers is at its highest. It is entirely equitable to provide a greater PTC benefit to current ratepayers who are shouldering the heaviest portion of the cost. Furthermore, EAL's cries of intergenerational inequity ring hollow when you look at their use of the Generating Arkansas Jobs Act or GAJA rider. Under the GAJA rider, EAL charges current ratepayers financing costs for strategic investments that are still under construction, meaning current ratepayers are paying for plants that will only serve future ratepayers. EAL cannot selectively apply the concept of intergenerational equity only when it allows them to hold onto ratepayer cash for longer. Finally, returning the solar PTCs through the rider FRP is problematic due to the rider's bandwidth and revenue constraint. If rider FRP hits its bandwidth limitation and results in a credit, the GAJA rider intercepts those amounts and applies them to strategic investments under construction to the benefit of future ratepayers. If the net change in required rider FRP revenue exceeds 4%, the 4% revenue constraint, the solar PTC benefit may be lost altogether. A separate rider ensures that PTC benefits flow back to ratepayers directly and transparently, without being reduced by other offsetting balances or statutory constraints. In conclusion, staff urges the Commission to reject EAL's NPTC rider as proposed and instead approve an NPTC rider with staff's recommended modifications, which include capping ratepayer liability for IRS disallowance at a maximum of 80% of indemnification costs, removing the company's carrying charges on those disallowance costs, and mandating no more than a 2-year return of principal upon a favorable IRS finding. For the solar facilities, we ask you to approve Walnut Bend as filed, but require a separate rider and a 15-year amortization for West Memphis and Driver Solar. Staff's proposed modifications are necessary to ensure that the risk and rewards of monetizing tax credits are balanced fairly between Entergy Arkansas and the ratepayers who ultimately fund these investments. Thank you for your time and careful consideration of staff's testimony.
Thank you, Mr. Parks. Has anyone signed up for public comment? No one has signed up for public comment. Is there anyone in the hearing room now that wishes to make a public comment? Seeing none, we will move on to procedural matters. The pre-filed testimony is admitted into the record. It will not be duplicated in the transcript of today's live hearing. Also, please note that the Commission's long-standing hearing rule will be in effect during this hearing, meaning that once the witness has been tendered for questioning by the Commission, Further redirect of the witness by counsel will not be permitted. Further, the parties are reminded that this case may include protected information, including highly sensitive protected information. Members of the public are advised that the hearing room may need from time to time be cleared with the exception of persons who have signed the proper affidavits of non-disclosure. Parties are advised to inform the commission if and when a party intends to reference confidential information, in which case the commission can determine whether to go into in-camera. Are there any motions or other procedural matters that need to be addressed at this time? Ms. Lyle.
Entergy Arkansas makes its standing objection to the application of the rule.
So noted and so denied. Ms. Law, I'm going to ask you to call your first witness, but let me tell you this first. When we get to the part of commissioner examination, we're going to ask you to present Ms. Whaley to sit next to Mr. Lewis. If Mr. Lewis is not the subject expert on any of our questions, he may defer to Ms. Whaley. That way we can get an answer and move on in the purpose of expedition of law. So if you'll call your first witness.
Entergy Arkansas calls Jay Lewis. Mr. Lewis, please state your name, title, and business address for the record.
Sure. My name is J. A. Lewis. I'm a principal of ASD at Work LLC, which is an entity through which I perform consulting services. My address is 3 Melrose Court, Monroe, Louisiana. And does that cover all the things you asked? Okay.
Are you the same Mr. Lewis that provided direct testimony and exhibits on February 26th and an errata to that direct testimony on February 27th, direct testimony on March 20th, and rebuttal testimony and exhibits on May 7th, and certiorari rebuttal testimony on June 5th in this proceeding?
Yes, I am.
And if I asked you those questions today, would they be the same?
They would.
So consistent with your order earlier, those are already admitted, and we will tender Mr. Lewis for cross.
So done. Sir, be sure and speak into the mic. It's
Yes, sir.
close to it. Mr. Parks, do you have a cross? And be sure and speak to us. You'll have the tendency to speak to the attorney. He doesn't matter. We're the ones that matter, okay?
I understand.
Sure. He actually matters, but we're the ones that make the decision,
I get it.
okay?
Yep.
And we have quite a few people that watch, and so that they sure want to hear your voice.
Sure, I understand.
Staff has no cross? You're sure you have no cross? Okay. Then we will move on to, I assume, no redirect.
Correct, yes.
Okay.
Would you like me to have Ms. Whaley come up for your question?
Yes, please. Perfect. Ms. Whaley, eat the mic, okay? That's the best thing I can tell you, okay? Those are sensitive, but they've got to pick up the voice. Get comfortable, get the mic right in front of you, okay? And pull it up to you if you need to.
I'll go this way.
Pull it
with
up,
it.
yeah.
And
How is this?
I'll just have her introduce herself for the record, if that's
Yes.
acceptable. So, Ms. Whaley, if you'll state your name, title, and business address for the record.
My name is Stacy Whaley. My title is Director Tax Regulatory. My address is 639 Loyola, New Orleans, Louisiana.
And Ms. Whaley, can you just generally describe your role within the company?
Sure. I direct a group of 5 people and we provide regulatory income tax support for various departments at Entergy.
And we'll tender
Thank you.
Ms. Whaley.
I want you to pull that mic up closer to you. You're going to get uncomfortable leaning into it all the time. Okay, there you go. That's
Okay.
probably works, okay, if it's comfortable for you. Ms. Anderson, do you have questions?
I do, Chairman. Thank you. Good morning.
Good morning.
Mr. Lewis, I want to begin by talking about how we got here today. In doing so, I want to refer back to order number 15 and docket 20-252U, which is the Walnut Bend docket. In that particular order, the Commission clearly set forth an expectation that a full and complete vetting of all EAL's PTC eligible resources, a complete vetting of those of EAL's PTC eligible resources as soon as practicable. That should occur as soon as practicable. Our order goes on to say that to the extent that there is an election of either investment tax credits or PTCs for eligible resources, we expect that this will also be fully vetted and approved before any such election by EAL. Here today, we're here today, you filed testimony stating that IRS formal guidance is still forthcoming. So no such notification has yet been provided in that docket. However, as discussed below, EAL has now monetized the nuclear PTCs in late 2025. Is that correct?
Yes, yes, it is.
Please explain why EAL didn't come to the Commission before the PTCs were monetized.
Sure. Let me, first set some background because I know these are, technical, kind of complicated issues. The question you're posing has to do with the nuclear PTCs,
It
not
does.
the solar PTCs. And the regulations require that if you're going to monetize PTCs, sell them to third-party purchasers, you have to do that before you file the tax return. So that decision had to be made by, I believe the deadline is October 15th, 2025, monetize PTCs for 2024. That's when the decision had to be made. My understanding is that Entergy Arkansas personnel were interacting with members of the staff of the Commission to discuss the alternatives. We did a net present value analysis that clearly indicates that monetization was the better of the two paths. That was reviewed with staff. I believe they concurred with that conclusion. And so the monetization was done at that point. We always knew that would need to be presented to the Commission for approval and review to agree that it's a prudent decision. We knew at the time that there was going to be a rate case being filed in 2026. I think the internal expectation was this would be a part of that rate case. So that's why there wasn't, at least to the best of my understanding, a formal filing before the rate case was made with regard to that monetization issue. Now, of course, the Commission issued the order establishing this docket, and kind of as you said, that's why we're here today. Seems like there was something else I wanted to say, but those are the thoughts that immediately come to mind. I guess what I was going to say is that, I'm not an attorney, and so I wouldn't want to be, passing legal judgment on what's required to be approved by the Commission. But I was a utility financial executive, and there are some decisions you make as a utility that are clearly implicate the regulator and regulatory approval, things like building plants, transmission lines, those sorts of things. Other decisions that are by their nature more operational, and this issue of how you take advantage of a tax position is one that I view as a more operational issue. Certainly the Commission obviously clearly has the authority to review that decision for prudency, but it's not the kind of decision I would expect a pre-clearance to be required from the Commission for, just coming from a business perspective, not a legal perspective. So I hope that helps to answer the question.
Well, it doesn't really explain why you didn't come to the Commission That order in the Walnut Bend case was issued in July of 23, where I believe the expectation was set forth very clearly that the commission expected a full vetting of all of that before the decisions were made. But let's move on. At what level was the decision to monetize the nuclear and solar PTCs made?
I would have to defer to Ms. Whaley on that decision because I wasn't involved in the decision. I'm not an internal
So
person.
you were not
Entergy.
involved, but
Right.
is that a question you can answer for us, Ms. Whaley?
Yes, I can. That decision would have been made internal to the tax department, along with, other external consultants that we would have used to help us or assist us in making that decision. So internal to the tax department.
And at what level of the corporation would that be?
I think it would be at multiple levels of the corporation.
All right. So that would have involved you and your team.
My team would have assisted in terms of the income tax accounting, in terms of, the modeling. We would have also, assisted in terms of the rate making or regulatory income tax effects.
Okay. And were you also involved in contract negotiations for the monetization?
I was not.
Okay. And do you know who would have been involved in that?
I think there would have been multiple people within Entergy involved in that. So people at the director level at Entergy as well as above that.
But other than you and your team in the previous question, is there anyone in this room that would have been involved in that in those decisions?
There is not.
Okay. That's all I have on that for right now. Mr. Lewis, I was looking at, we touched on the prudence of the decision to monetize. Can you point me to any of your testimony that was provided in support of the prudency of that decision? Did you testify to any?
I believe I did, in the sense that, let me explain the issue a little bit. I believe this is reflected in my testimony. The decision to either monetize or utilize, or that is the decision to be made, right? Should we monetize and sell the PTCs, or should we utilize them on our return? In my testimony, I support that the decision to monetize was a prudent decision because of the timing of when essentially the funds would come in. It's a time value of money issue. If you monetize, so picture in your mind, right, we've got $1 of a tax credit we can claim on our tax return. If we monetize it and sell it, there's a cost involved in that. So broadly speaking, let's picture that to be 5 cents. So we can today receive 95 cents for that $1 tax credit.
Look, can you kind of point me to your testimony where and then let's walk through it, but can you point me to your testimony where you believe you're discussing the prudency of the decision to monetize?
Yeah, give me just a moment, Commissioner, to
That's fine.
look
And I
through
know
my
there's
testimony.
It's a little confusing with two directs.
That's fine.
In my direct testimony, my first direct testimony filed in this docket on February 26th, there's a discussion that begins on page 13 of this issue of monetization, why EL made that decision. So, that's what I was referring to, Commissioner.
Okay, thank you.
when I
And
stated
now
that earlier.
proceed. If you'll
Sure.
walk me through that, through the prudency of that decision to
Sure.
monetize.
Sure. So there's example one. The monetization occurs, you get 95 cents today, right? The other alternative is to take that $1 deduction that you're claiming and use it to reduce your income tax payments. The complication comes if you're not currently in a tax-paying position, and Entergy is currently in an NOL position. So claiming the deduction doesn't result in the reduction of your income taxes, right? So what the NPV analysis I've referred to reflects is when those PTCs were expected to be utilized, and an NPV calculation was made to determine, is it better to get the 95 cents today or to get the dollar at some point in the future? That calculation didn't indicate that it was a close decision. To again use kind of rough examples, where claiming it in the future on future tax returns when taxable income is expected would produce, let's say, $1 of value today in NPV terms when you discount it back to today. Getting the money today is 50% more valuable. So it was not a close call. In terms of dollars, tens of millions of dollars of additional value to EAL's customers through monetizing today for the 95 cents instead of deferring the receipt of those tax reductions on your return in the future is the essential issue. That's the comparison that was made. I hope that's helpful.
Okay, that's fine. Chairman, I don't have anything else right now. Thank you.
Mr. Lewis, I respect the fact you're not an attorney. I've practiced law in this great state for 40 years. One thing I've learned in the practice of law, if I'm not clear on the meaning of an order of the court, I would petition the court and ask for clarity. I would not assume that I knew what that order meant. And if I made an interpretation of what that order meant, and it was not the meaning of the court, I would have a penalty to pay. So my question to you is, what is the appropriate penalty taking this action unilaterally on the part of EAL to monetize these PTCs after the commission clearly expected you to come to us first before any action was taken and that we would vet it? And you did that in Louisiana. You did not do that in Arkansas. Okay? So tell me, what is the appropriate penalty that we should levy against EAL for failure to follow the clear orders of this commission?
Sure. I couldn't speak to what the appropriate penalty would be, Commissioner. And
you understand there should be a penalty.
Well, I guess it depends on it
is an order of the commission, sir.
I understand. And, my impression was that the issue had to do with, when IRS guidance was produced regarding the credits, and that's why there wasn't a filing made previously.
But there was one in Louisiana in advance. Clearly, you recall that, don't you? Are you aware of that?
I wasn't involved in that.
Ma'am, were you involved in that?
I was not involved with any
Okay, y'all need to
negotiations
read the
with
record of
Louisiana.
Louisiana and see how much vetting was done by the Louisiana Commission in advance of the selling of those PTCs, and how we had a clear order in effect. And if you didn't think it was clear, I think you have a few attorneys on staff that could have petitioned us to find out clarity. It's almost like you didn't intend to follow the order of this commission. I just want to state that. That's my question. I knew what your answer was going to be, and I appreciate it. Mr. Tate, questions from you?
Thank you, Chairman. I want to clarify something that Commissioner Anderson asked. I think in response to her question, you indicated that Order 15 only applied to nuclear PTCs. Is that accurate?
Well, I would need to understand what aspect of Order 15 you're referring to. What I think I was talking to Commissioner Anderson about with regard to nuclear PTCs is the issue of monetizing versus claiming on the return, and the issue of the risk of future IRS action in that regard. But I'd be happy to look at the order you're citing and to answer your question more specifically.
Well, to be clear, the commission was pretty clear that we were talking about all of EAL's PTC eligible resources, so not just nuclear.
Right, and I didn't intend to indicate, Commissioner Tate, that the order only had to do with nuclear PTCs. I was referring to the unique aspects of those PTCs. So if I
Understand.
misspoke, my
Yeah, and
apology.
we'll get to the unique aspect of those in a minute, but you also suggested that you thought EAL's obligation was to notify the commission after you'd received some IRS guidance. Is that accurate?
That was my impression of what the order was, that when there was guidance from the IRS, that a filing with the commission was required at that point.
So you're partially correct. There were multiple requirements under that order. One being EAL notify this commission within 30 days of receiving guidance. So you are clear, you are correct on that part. There's a separate expectation in the order that explicitly says that the commission expects the election of ITCs or PTCs for eligible resources will be fully vetted and approved before any such election.
Mhm.
That's, I think, where this commission is a bit frustrated, to say the least, that that order was issued in July of 2023, and we're here today talking about an election that was made previously, right?
Sure, and you know, I guess a couple of thoughts related to that. One, you know, again, there was that you know, looming deadline of selling the PTCs or not being able to sell them with the filing of the tax return that was a part of that decision as well. You know, there were ongoing conversations with staff, and I know, you know, that's of no comfort to commissioners, but the company was talking to staff about the decision and which decision was best, and there was a consensus in that regard. But I know that doesn't directly address what you're asking.
Are you suggesting that there wasn't sufficient time to come talk to the commission about that issue before you elected to sell them?
I don't know if there wasn't sufficient time, but the fact that that deadline was looming, you know, necessitated a decision. I'm not saying there wasn't time to review it with the
You
commission.
were aware of the deadline ahead of time, and again,
Yes,
we
we
had
would have
previously
been.
told you back in 23 this was an expectation. So I'm
I'm
struggling with why that didn't happen if you were given prior notice
Right.
and you knew of the deadline
No,
coming
no,
up.
I understand your question. I'm just speaking to when the decision to make the sale being affected by that.
This may be a question for Ms. Whaley. I was a little unclear with Commissioner Anderson's question about at what level the decision was made to monetize. Was that at the Entergy Arkansas level or at Entergy corporate level?
Entergy Corporate, specifically Entergy
Okay.
Services LLC.
Were Entergy Arkansas employees involved in that decision?
I wasn't directly involved with those conversations. However, our tax department typically does communicate with each of the jurisdictions whenever it is making a decision that will affect the tax return. It will also affect any of the jurisdictions.
And that was done because of Entergy filing a consolidated tax return. So the decision was made at Entergy corporate, and then Entergy Arkansas was notified that the PTCs generated by their resources would be sold.
That is correct. So it is, the decision is made based on the Entergy Corporation consolidated tax return. But it does obviously affect each of the jurisdictions who are part of that corporate tax return. And so it's typical of the tax department to communicate with management at different levels for each of those jurisdictions for major decisions.
And the negotiations over the contract to sell those PTCs, what level was that done at?
I think that was also done at multiple levels. I will say that I was not in any way involved in those negotiations. I did not work on that. But I do know that it was at, you know, multiple levels. I would say it was at least at the vice president level. And in addition to that, probably folks, you know, at the director and senior manager level were also involved in those decisions and assisting at the time.
Do you know if any Entergy Arkansas employees were part of those negotiations?
I do not.
Do you know when the decision was made to monetize?
I don't know the exact date that that decision was made, but in terms of our Form 10K, you know, I know that we have some disclosures in the 10K that occurred in 2025, and some journal entries that occurred at that time as well. And so I believe the decision was probably made in line with getting prepared for the tax return that would be filed in October of 2025. And so the decision was likely made sometime in early 2025 or late 2024 in preparation for that tax return. And so those negotiations could occur to sell the PTCs with a goal for the cash to be received prior to the filing of that tax return.
So I could be mistaken, but I think it was included in your, quarter 2 10K filing that you were going to monetize? Does that
Which
sound-
quarter of which year?
25.
I'm not sure if it was that exact quarter, but I can say that it was within the 10K at the
Okay.
end of the year.
But you think potentially the decision was made maybe as early as late 2024 to monetize?
I cannot say for sure, but I know for sure that it was made within the first part of 2025. I do not know the exact day or the exact month.
Can you explain for me the process Entergy goes through once it's made that decision in finding a buyer for the PTCs?
I know that they use a broker
Okay.
to do that. And I know that for the particular sales at, question today, which are for the 2024 PTCs, we did have 3 buyers.
And do you know at what point Entergy would have contacted a broker about trying to sell PTCs?
I do not.
Do you know kind of generally, do you have experience with this in the past? Not specifically these PTCs, but using a broker to sell tax credits?
I do not.
Okay. So you don't have any idea how long that process would take?
I do not.
Did Entergy ask for an IRS private letter ruling?
Entergy did not ask for an IRS private letter ruling because you can't ask for an IRS private letter ruling in this instance. And that's because the IRS has said that it is going to provide guidance in terms of the uncertainties around the gross receipts for the nuclear PTCs. And so it will not produce responses to PLRs for particular taxpayers in this instance. It's not a possibility.
Right. So you're saying they won't issue a private letter because they've already said they intend to issue guidance at some point in the future.
That is correct.
And you're expecting that guidance by 2030, or is the 2030 date related to when the audit will be over for the tax year in which these specific PTCs were monetized?
So I did hear 2 questions there, so I'll try to answer them both for you.
Thank you.
So we have no indication of when the IRS will issue that guidance. We don't know.
Okay.
In terms of the 2030 year, that's associated with our 2024 tax return specifically, and when we expect some type of determination from the IRS related to that tax year only.
Have you had any other contact with the IRS about these specific PTCs?
I have not, and I'm not aware of any contact within the tax department outside of myself.
So I'm going to read for you an excerpt from a filing that the CFO and treasurer of Alabama Power made with the Alabama PSC. This was done back in September of 2025. The CFO stated, the company has pursued discussions with the IRS regarding the requisite determinations, with multiple follow-ups on various questions, refining the calculation. During May of 2025, a method for computing gross receipts for 2024 was provided to the IRS and, following review, was accepted pending the completion of documentation substantiating compliance with certain elements of the calculation. Has EAL similarly pursued discussions with the IRS regarding those determinations?
To my knowledge, it has not. We would pursue those conversations as part of our IRS audit. And our IRS audit is not expected to start until sometime in the future. We don't know the exact date, and we expect that it will conclude or we'll get a determination sometime around 2030. To the extent, I think it was Alabama that you just read from.
Yes.
Did you state that again?
Yeah, it was Alabama.
Okay. To the extent that Alabama made some type of public disclosure surrounding its IRS audit and its communications with the IRS and a determination that it received, that would have no bearing on what occurs for Entergy. Entergy has to work with the IRS on its own to determine what its treatment will be. We cannot use what has been decided for another taxpayer.
Yeah, this wasn't read to suggest this is what the IRS has said is okay. This is to suggest that Alabama Power specifically, has taken steps to, or pursued discussions in their own words, with the IRS about how they intend to do this. And my question is, has Entergy, you indicated they have not, and that wouldn't occur outside of the normal audit process? Can that occur outside the normal audit process?
It's my understanding that it cannot. Some taxpayers are on expedited audits, and
Okay.
so, they're able to do an accelerated process through an accelerated program. Entergy is not a participant in that program.
Okay. So at this point, Entergy has not provided to the IRS its method for computing gross receipts.
Well, we filed the tax return, but we haven't had any communications with the IRS because the audit of that year has not occurred.
Okay. Can you tell me any steps Entergy has taken to minimize risk to ratepayers?
I believe that might be a question more appropriately asked to Mr. Lewis.
Mr. Lewis, can you answer
Sure.
that?
Sure. You know, in terms of risk to ratepayers, let's step back and review a little bit what Entergy is proposing for the regulatory treatment of these nuclear PTCs with this separate, rider NPTC that Entergy Arkansas has proposed. What it does is it provides weighted average cost of capital returns on the monetization proceeds until the time that there's some determination from the IRS, be it a ruling or be it the completion of an audit or the expiration of an audit period, that verifies the amount of the PTCs that the IRS has agreed that Entergy Arkansas can claim. Right up until that time, customers are getting weighted average cost of capital benefits on those proceeds. At that time, if there is an adverse decision from the IRS, there will be some costs involved. That indemnification haircut, the difference between the dollar and the 95 cents I referred to earlier, the buyer of the credits will, of course, be wanting their money back for the portion that's disallowed. As well, the IRS may charge interest. Those costs will at that point be amortized to customers through rider and PTC. When you look at the picture in total, it's difficult, it's unlikely in my view to envision a situation where the net result is a harm to customers because of the approach that's being taken. It would have to be some extreme outcome such as the IRS issuing a ruling in the near future that completely disallows PTCs for nuclear units, that results in the PTCs having no value, where customers haven't received that WAC benefit for any lengthy period of time and they're fully disallowed. It would be some extreme circumstance like that would result. We fully expect the net result of this, when the dust settles, so to speak, to clearly be a net benefit for customers.
So as far as the indemnification costs, can you tell me what all that includes?
Sure. Essentially, the buyer of the credits, right, wants protection if the IRS rules negatively. So, we talked about $1. If the IRS says, well, no, that's 70 cents, right? The buyer wants 30 cents back. Now, the buyer will, of course, use that 30 cents partially to pay the IRS for the deduction it took. From my perspective, it's that 30% of the 5% haircut, right, that is a net cost to customers. I hope that's helpful.
Yeah, that's not all of the indemnification costs, though, right?
Well, the total the indemnification costs can be are the reimbursement of the credits to the buyer if they're fully disallowed.
Yeah, there are other costs that Entergy is proposing ratepayers would be on the hook for associated with a disallowance. Is that right?
Well, that's right. There's the indemnification cost. There's the potential the IRS will charge interest for the period that the credits were claimed. And there's the potential, though we think it's very unlikely, that the IRS would charge penalties. They haven't, issued a decision on this issue, so we think that's very unlikely that they would do that, but that's a possibility. Entergy is committed to not pass those penalty costs through to customers if they are incurred, right? But otherwise, it's just that essentially reimbursement of the credits and then the interest are the two costs we're talking about.
So that language was pulled out of the FERC filing. Is Entergy making that commitment today that it's not going to seek any penalties imposed by the IRS on the retail level as well?
I believe that commitment's been made, yes.
Do you know what the interest rate is that the IRS charges?
My recollection, first of all, I think it's updated at least annually, perhaps more often, and it's based on some kind of index. I think currently the IRS interest rate is 7%.
I think it's higher than that.
I'd defer to Ms. Whaley if she knows
Do you know
the
what
details.
the current interest rate is that the IRS charges?
I agree with Mr. Lewis. I believed that the rate was 7%. If it has been updated and is higher, I'm not familiar with a higher rate.
You would agree, though, that it's higher than WAC.
I do. I agree that it's higher than 6.75%.
Okay.
It is, and I would interject, Mr. Tate, that that's an unusual result. You wouldn't expect the IRS interest rate to be higher than a company's cost of capital. It's a result of the Commission's use of the MBSA and having those zero-cost capital items in capital structure that pulls weighted average cost of capital down. That's what causes that relationship, just as a note to your question.
So why shouldn't the Commission then use an interest rate that matches what the IRS will be charging or using?
From the company's perspective, the benefit of funds is the weighted average cost of capital, but certainly the Commission has discretion to, make decisions in that regard.
Now, I believe it's your testimony that customers are receiving all of the benefits of this. Is that accurate?
Yes, it is.
So are you suggesting there are no benefits that the company is receiving?
From my perspective, there are no benefits that aren't being provided to customers when a company receives money, as we've received with these PTCs. It pays a cost of those funds, right? If a company issues bonds in the marketplace, it pays an interest rate. Obviously, there's the issue of, the cost of equity capital if you get equity funding. In this case, we're providing a full weighted average cost of capital, which is obviously higher than the debt rate, to customers. There is no more benefit of those funds that I could see that a company would provide to its customers when it's providing a full WAC return on those proceeds.
Well, I'm not sure a benefit has to be either a customer benefit or a company benefit, right? Some benefits can be shared by both.
Oh, sure, depending on the particular regulatory situation.
So I'm to be clear, do you think the company is there any benefit to the company in monetizing these PTCs?
It gets into the issue of when utilities do things for customers, whose benefit is it for? Clearly, the company saw it as advantageous to claim these credits and, receive these proceeds through monetization. But that clearly is something that relates to customers in the utility business, so those benefits flow to customers, right? It's no different, I guess, in my mind, than when a utility invests in plant, and charges customers a return on that plant. Those assets are serving customers. The customers are paying for it. So does the company benefit from it? Well, it helps it run the utility, right? But the benefits are dealt with in the regulatory framework.
So it's going to be a little well, I can probably refer you to a document number. Let me make sure I've got the right one first. I'm looking at document number 31. I think you filed 2 testimonies that were labeled as direct testimonies. So I think it was the first one you filed.
Okay.
In there, you talk about you're proposing a balanced process to let customers immediately begin receiving benefits, while also protecting EAL from an adverse IRS outcome. Can you tell me, as part of this process and the decision to sell or monetize the nuclear PTCs, who's protecting ratepayers?
I believe the commission would be in approving this structure because the structure gives customers full WAC benefits of these proceeds from day one. We had originally designed the rider to begin on June 1st. Obviously, that won't happen, but assuming the commission approves the rider, those benefits will begin to flow to customers immediately. And I can't overemphasize the importance of understanding that those benefits going to customers, right, in their bills dollar for dollar, is a benefit to customers. And I fully anticipate, as I said earlier, that those benefits are going to outstrip any negative results from the resolution of these PTCs. So customers are benefited through the structure, is the way I would view it. Or protected, I should say.
We'll talk about that, but you didn't specifically address the question as part of this process and in the decision to monetize, who was protecting ratepayers? This wasn't a decision apparently made at the EAL level. You note that, the company took steps to protect EAL from an adverse IRS decision. My question is, as part of that process, who was protecting ratepayers? Because this was not brought to the commission in advance. We are now looking at this issue after a decision has been made.
Mm-hmm.
So who, as part of that process, was protecting ratepayers?
Well, the structure was certainly designed with ratepayers in mind. This is a customer beneficial tax position that's going to result in credits flowing to customers. The structure provides customers the full benefit of those proceeds. To my mind, there's a kind of a fundamental issue of symmetry here. If customers receive the full benefits of the proceeds, then the costs of obtaining those proceeds are also properly flowed through the regulatory model. So the customer is certainly not a part of that decision process. The reason Entergy, any utility, takes tax positions that benefit its tax payments is to benefit customers through reduced tax payments. So the ratepayers, the customer is always in mind when these decisions are made.
What happens if the IRS disallows this? Customers are responsible for paying back the entire amount, not just the proceeds, correct? Including the 5% discount, including a higher interest rate that the IRS charges than the WAC they've been receiving on the proceeds, and potentially any penalties. Plus, as I understand it, as part of the contract, there are some other provisions for costs that ratepayers would bear in defending EAL's and the buyer's position on this. So walk me through the math, how customers will ultimately still benefit even if the IRS disallows this.
Well, sure. Now, again, the issue is the extent of the IRS disallowance, right? The more the disallowance, the more the net benefits, get closer together. But let me again emphasize that customers are getting those WAC benefits all the way through that period until an IRS decision is made. As I indicated earlier, penalties won't be charged to customers, and we fully expect whatever net result occurs there to be beneficial to customers. Now, what would happen, which I think was really what your question is those costs that are incurred at that time, right, will be set up as a regulatory asset and will be amortized to customers over the same period that they received WAC benefits. So for example's sake, let's say that there's a 4-year period between when the credits begin and when there's an IRS determination of the ultimate result of those credits. Then, in that case, the costs that are incurred upon an IRS disallowance of some portion or all of the credits would be charged back to customers over a 4-year period. It might be appropriate for me to say, Commissioner, because I understand the concern and I understand the question about, what about these costs on the back end that aren't fully known right now. Obviously, you commissioners are charged with thinking about the customers of Arkansas, so I don't mean this in any way to indicate otherwise, but Your fellow commission's been struggling with this same issue, and they've taken different approaches. If you look at the Mississippi Commission, what they've said is let's not begin flowing credits back now. Let's wait until the issues are resolved, and at that point, the net benefit of the credits will be flowed to customers, net of the costs that are incurred. Now, in that case, they're only going to get in that case, in Mississippi's case, customers won't pay those costs. The costs we're talking about, indemnification and interest, right? But customers are only going to earn a debt rate on the proceeds, since there's not that risk symmetry that I referred to earlier of customers getting the full benefits. So that's the way the Mississippi Commission's dealt with that issue. Let's hold off. Let's just give customers the debt rate return on the proceeds, and let's wait until we know exactly how much money we're dealing with, and then amortize the net benefits to customers. So there are different ways you could do it. The way we proposed in Rider NPTC in this docket was a result of discussions with staff. There was a desire that credits begin to flow to customers immediately, right? There was a desire those credits be as big as possible, which is the WAC rate, and that's what you see in what we then designed to make that symmetrical.
Desired by who?
I believe both staff and the company.
Okay. Do you know when Mississippi Commission made their decision?
I do not off the top of my head, Commissioner.
Do you know when Entergy took that decision to the commission?
I don't. I wasn't involved in
That
the docket.
proposal?
Yeah.
Are you familiar with what Louisiana has done?
Broadly, in Louisiana's case, it's similar to Mississippi's in the sense that the credits don't start immediately. Rather, they're deferred until there's an IRS decision.
Right, they're not flowing anything back until an IRS decision.
Right. Now, in their
Now,
case,
I believe it's earning WAC,
they're earning a WAC rate.
but their WAC is higher.
Their WAC is higher because of the MBSA I mentioned earlier. That
Do you know how often that interest is compounded in Louisiana?
I don't. I would assume annually, but
It's
I don't.
quarterly.
And so in that case, customers will bear the costs as well that we're talking about. So that's kind of the symmetrical approach that we see of return and risk, right? WAC is a full return, so that means customers bear the risk of those future costs. Debt rate is just essentially borrowing money, so customers don't bear the cost. That's kind of the symmetry I think you see in some of your sister commissions.
But you're suggesting the difference between what is being proposed here and what has been done in the other states is because of conversations you've had with general staff?
That's my understanding. I wasn't involved in those conversations, but that's
Okay.
my understanding.
Let me
We'll
interrupt.
have an
Who was involved with the staff?
Uh,
If you weren't, who was?
with the staff, or
Yes.
from the staff side,
No.
No,
from
from
Entergy side.
Yes.
I'm sure David Palmer was.
Okay.
There may have been others,
Okay.
but I'm sure Mr. Palmer was.
Ms. Worley, do you know?
I do not.
Any other staff?
I do not.
Okay, thank you.
We'll have an opportunity to ask staff about that. I think it's interesting that you suggest that you crafted this based on conversations with staff, but clearly staff is not in agreement with your proposal.
I'd have to defer to them to explain that. What I can do is defend our proposal, which is symmetry.
We're going to shift a bit. Ms. Whaley, this is probably for you. Can you explain what a FIN 48 liability is?
Yes, I can. A FIN 48 is an uncertain tax position. It's under an accounting standard. In today's world, it's under accounting standard ASC 740, but FIN 48 is the old FASB standard, and we still refer to it as a FIN 48 uncertain tax position.
So walk me through the process you use to evaluate tax positions for that. It's a two-step process, right?
Yes, it is. I do not directly work on that process, so I'll start there. There's another director that is in charge of that process. But the two steps is, first, you have to determine whether or not it is not more likely than not that you will have success with a particular tax position. And once you've determined the population of tax positions that fit there, Then you have to determine the probability of your success associated with that position. And so there's some type of probability associated with it to determine how much of a reserve you need to record on your financial statements associated with such tax position.
Are you the same Stacy Whaley that testified in the LPSC docket back in 23? I believe it's U336-959.
I did testify in an ELL docket before the LPSC in written testimony only.
Okay. Do you know what the determination was made in relation to the monetization of the nuclear PTCs here? Whether it was determined that it was more likely than not that position would prevail in front of the IRS?
I think that it was determined that the position was an uncertain tax position using the two-step process that I described earlier. But I think the main reason for that determination was due to the lack of guidance from the IRS on how to calculate the gross receipts associated with nuclear proceeds, nuclear PTCs.
So walking through the two-step, step one,
First, you determine whether or not it's not more likely than not that a position will prevail under audit. And then the next step is determine the probability associated with the population of positions that you feel like you have some uncertainty around. And you'll determine a percentage, if you will, associated with that position. And that percentage is used to determine the amount of the reserve that you put on your financial statements for SEC purposes.
so here it was determined that it was not more likely than not going to prevail. That's
It is
a weird
lot.
way to word it, but essentially, the company felt that it was likely to not prevail given the lack of guidance from the IRS. Is that
There was a probability of that, right? And so, yes, you're correct. The company did determine that this was an uncertain tax position under the FIN 48 standards that I described. And yes, the company did record a reserve on its financial statements from an SEC perspective for that.
so? Again, let's talk about the second step then. You said a percentage is put on the financial statement based on the probability. Is that?
That is correct.
Do you remember, or do you know what that number was? What that was for these tax credits? What was put on the financial
I
statement? what
believe
was
we would have
recorded?
to go HSPI for me to talk any further about that.
Is that accurate, Miss Law? Can you point me to the page where that's included? I believe that's included in a 10K filing.
Can you repeat I just want to make sure I understand. the
Speak
question.
into your mic.
Sorry, I just want to make sure I understand the question.
So this was recorded as a FIN 48 liability, right? Through that process, once it's determined, so step one is whether it should be included as a FIN 48 liability. Is that fair? That's
Yes, that's fair.
Step two then is what is the percentage, and that amount is what is included as the liability. I believe that's included in your 10K filing. I'm not sure why that's HSPI.
I have the 10K filing here. If you'll give me just a moment, I'll
Sure.
locate where we talk about that uncertainty, and I'll see whether or not it provides the percentage.
I'm happy to give you a minute to look at that.
I failed to bring my glasses up with me. Could someone grab them for me?
Chairman, we've also been going for a bit. I don't know if you are inclined to take a break or if you want to hold off till lunch.
Why don't we, while she looks at that, let's take a 15-minute break to 11:15, okay? We'll be in recess for 15 minutes. You may be seated. Miss Law, I have a lunchtime homework assignment for you. I would like to know when the order was entered in Mississippi, when the conversation started, and if there was a motion filed with the commission in Mississippi to determine how to sell the PTCs. We know the case in Louisiana, but I'd like to know the same in Mississippi, okay? It appears, at least to me, clearly in Louisiana, there was respect shown for the Louisiana Commission before actions were taken. I want to know if that was the case in Mississippi, and if we're just the redheaded stepchildren of these three states, okay? Thank you.
All right, I think we were talking about the FIN 48 that was listed in the 10K. Do you have that?
I do have it. I'd also like to offer up one clarification around the steps regarding the FIN 48.
Sure.
So I missed a step in the beginning. So the position can either be more likely than not or not more likely than not. This particular position is more likely than not, which means that the company had to put a full reserve on under FIN 48. And that is stated in the 10K, so we don't have to go HSPI for that. If you'd like the page number, I can provide it.
I think I have the page number,
Okay.
but can you clarify more likely than not what?
More likely than not that it will, well, more likely than not to be successful, I think.
You listed it as the full amount as a liability if you're more likely than not to prevail in front of the IRS?
I probably got that incorrect. I apologize. I know that more likely than not is a probability of 0 to 50% of success. And if you have that or going under audit, and I think if you have that probability, then you have to put on the full reserve.
Okay. I will readily admit this is not an area that I'm super comfortable with, so I'm going to ask again because I'm not clear. What was the company's position on this? Did it believe it was more likely than not to prevail in its position? And how is that reflected in its FIN 48 liability that it listed?
There is a full reserve on the books related to this position.
And is
Because
that
that's-
because the company felt like it would prevail or would not prevail in its position? Logically, it makes sense you would list the full liability if you didn't believe you would prevail, but again, this is not an area I'm very familiar with, so I'm asking.
Correct, and I will state, for the commissioners and the chairman today, that this is not an area that I'm responsible for the company. So I want to state that clearly. I have some familiarity with it because I have testified to it in the past. That was in 2023. I do not deal with it daily as part of my job in regulatory income tax. So I do want to state that out loud. So what I do know is that it was found to be more likely than not. And what I also know is that meant a 0 to 50% chance that it would go under audit. And there's no probability assigned in that respect. So the step I talked about earlier where you provide a percentage of probability of success with a particular position is when it's not more likely than not. And so, being that you have to put a full reserve on, I think there's a higher probability that you feel like you would not win the position under audit. And so you put the full liability on.
If you would let me ask a question.
Yeah, of course.
If you're not the person responsible for that, who is? What's their name?
Sure. At Entergy, that's Paul Schott, who is a director with the company.
And where is that person located?
He's at corporate.
Okay. Ms. Law, we will probably at some point recess this hearing until you can supply us with that person. Because our order directed that people appear before us that could answer all of our questions. Okay? No debate on that. Okay? It's just yes, sir. Okay? Thank you. You may proceed.
Ms. Whaley, I'll do my best to use the terms that I think are regularly used in regards to this. So, if the position is not sustained by the IRS, would this be considered a large corporate underpayment or just an underpayment?
Entergy is considered a large corporate taxpayer.
You don't know whether this amount would be considered an underpayment or a large corporate underpayment? As I understand it, that affects the interest rate that the IRS would apply.
I do not.
Okay. The 7% number I think you were quoting before would apply to just an underpayment.
Mm-hmm.
As I understand it, a large corporate underpayment is any amount owed more than $100,000, which we're talking numbers much larger than that here. That interest rate is higher than 7%. So I'm curious if Entergy's taking the position that this wouldn't be a large corporate underpayment, or why 7% is the number that Entergy believes would be associated with this from the IRS.
Yes, 7% is the interest rate I've been familiar with in discussions with other tax management at Entergy.
Okay.
However, I cannot say whether or not, we consider it an underpayment or a large corporate underpayment.
Mr. Tate, may I ask a couple of questions?
You can interrupt whenever you want, Chairman.
May I do so?
Absolutely.
Mr. Lewis, a couple of questions for you. Are the proceeds from this sale, this monetization of the PTCs, held in a separate account? Are they being used to supplement EAL's cash flow?
They're being accounted for in a separate account, regulatory liability that's accruing the WAC return that we've talked about. The funds haven't been segregated from a cash management perspective. They've been used for general corporate purposes like all other
So
funds
they could
that
be
come into the
invaded,
company.
is what you're saying.
Could be.
Let's be clear. They could be invaded to supplement your cash flow.
Being used for general corporate purposes, yes, I believe that's correct.
Well, in Arkansas,
Yes, sir.
we have IOTA accounts when we're lawyers, and if we invade customer funds, like in this case, or client funds, ratepayers' funds, we could lose our license in Arkansas. But I just want to be clear, they can be used to supplement the cash flow of Entergy, and they are being used for that purpose.
That's my understanding,
Okay.
Commissioner.
Thanks, sir. You may proceed.
When you say they're being used for general corporate purposes, do you mean they're going in like the money pool?
Yes, those sorts of cash management tools.
Right, so those are PTCs related to facilities here that Entergy Arkansas ratepayers are paying for, but it's being put into the money pool that benefits all Entergy OpCos, right?
Yes, that's correct.
Okay. The commission said in a previous order that those funds should be segregated out in a different account. It's Entergy's position they felt they complied with that by accounting for it separately,
Yes,
not holding it out separately in a separate account.
that's my understanding. Yes.
Okay. Ms. Law, I'm going to ask questions about stuff that was held as HSPI in the exhibits. I would like to attempt to do so without clearing the room, but I need to understand what is HSPI, because the entire, there were large sections of the exhibits that were held as HSPI. So I've got questions about some outside assistance the company got in regards to this matter, and I need to know whether identifying who they used is HSPI or just potentially the amounts paid to those entities were HSPI, or if it's Entergy's position that all of that, even me mentioning that you use somebody outside, is HSPI.
Right. So I think that we've acknowledged that we use somebody outside publicly, and I understand the confusion. I think that's coming from the compliance exhibit to
Yes,
right,
ma'am.
the FERC filing, and I apologize. That is confusing. We were attempting to make sure we filed it in exactly the same form as what was at FERC, which is why there's a large stack that is indicated it is highly sensitive, but there's also a very similar stack that is filed publicly. And so I'm not sure if you have a page reference where you were looking at that, because I can easily discern that, or I can.
Yeah, and I didn't print out the entire public version. The page I'm looking at is 1347, and I thought there was a large section between like 1200 and maybe the end that was all held as HSPI.
Right. So some of that, again, that's where the FERC filing was a bit confusing. Not all of that is HSPI. There
Okay.
just wasn't a way in the commission's filing system to segregate it because
okay.
it was one filing. So
Okay.
the way theirs works. So some of it may not be. So if we've got a page number, we'll pull it up here and we can just answer your questions one by one. And if if it is HSPI, we can certainly indicate. And if not, then
Okay.
we can answer. And again, I apologize. It was a little bit confusing. I think, Stacy, this question might end up being for you if you want to pull up the page number.
Do I need to repeat it?
You do.
1347 of Exhibit 2 is what I'm looking at.
And that's the page number, Commissioner Tate, at the top or the bottom?
Let me pull it up myself and
Sorry.
verify. No, that's a fair question.
We were trying to make sure we preserved exactly how it was filed at FERC. So
So it is at the top.
I'm verifying that before we start, so there's not any confusion. $13.47.
1347 at the top.
I think we got to the page, and just perhaps to help Ms. Whaley, since I know it's also confusing that it's, I think we can disclose publicly who we were using, but the rates and that information would be HSPI.
Okay.
If that's where the questions are headed.
Okay, I found it myself. All right. I believe it's 1347 at the top of the page. I think it's 1359 of the PDF, and I think it is 13. Let me see. Yeah, 1355 at the bottom of the page. We all clear? Is talking about, so the charges you guys would hold out as, or want to hold out as HSPI.
Yes.
What about the description of the services provided?
I think. Yes. That would also be HSPI in this instance.
Okay. You want to clear the room, Chairman, or do you want to come back to this?
Let's go ahead.
Go ahead.
Clear it.
Sure.
If you haven't signed a disclosure, we need you to step out of the room. We're going to go in Cameron. You may proceed.
Well, we touched on this before. Why don't we just start with what I think is probably the most important question. What is Entergy's evaluation of its likelihood of success in this position in front of the IRS?
Entergy has a full tax reserve, a full uncertain tax position on this particular item.
What does that mean?
There's a full reserve against the value of the credits.
Separate from the PTCs?
It's a separate balance that is on our trial balance that is an offset to the value of the PTCs.
Thank you.
But I'd like to clarify that that's what's required under the accounting standard. So Entergy didn't make that determination through some type of probability, as I had described earlier. The accounting standard requires the full reserve.
So are you telling me Entergy didn't do an evaluation of the risk associated with this position?
I believe they did do an evaluation of the risk associated with the position under the accounting standard and determined that it was more likely than not. And so that determination is what requires the full reserve. That's the extent of my knowledge.
Mr. Lewis, did you model any risk into your NPV in determining whether it was more beneficial to monetize versus utilize these credits?
The NPV was based on, the credits that were taken, right? So there's not a risk modeled into that. However, I do believe that, the scenarios where there's a net harm from the position are pretty remote from our perspective. And
what is remote about it? The likelihood that you won't succeed, or just that
Yes.
ultimately it'll result in harm to ratepayers?
Well, ultimately harm to ratepayers, ultimately that it's not a good idea to take the credits, right, is what you would want to consider, and that wasn't our Entergy's conclusion. I guess I hesitate a little bit to offer this, but you have the good or bad fortune, your judgment of having an accounting professor testifying before you, I believe what you hear in the discussion with Ms. Whaley is the accounting rules around uncertain tax positions, and what she's describing is kind of a bright line accounting rule of anything that's below 50%, right? So what 0 or whether it's 49, it's the accounting Ms. Whaley's described, and I believe that's what you're hearing. So back to your question, I haven't seen modeling of different scenarios of success and failure that might have been done internally. It wasn't submitted with my testimony, but I am confident that Entergy does not believe that at the end of the day, this is a position that will result in harm to ratepayers, because we wouldn't take it if we thought it would.
What harm would there be to Entergy if the IRS disallows this?
Entergy may have to pay penalties, as I indicated earlier, right? Certainly would be required to pay the interest, indemnify the buyer, et cetera. Those costs are dealt with in the rider, as we've talked about.
And as proposed in the rider, you have ratepayers covering all those costs except penalties, which you said would be remote anyways. So
Right.
how is that a harm to Entergy if ratepayers are on the hook for all of it under your proposal?
Well, we will have provided customers a WAC benefit for some number of years.
Less than the IRS interest rate.
Yes, because of the way cost of capital is calculated here in Arkansas. But we would have provided a benefit to customers for a position that we didn't succeed on. That's a real cost.
Well, it looks under the contract like the buyer is made whole. Entergy will pass through all the costs, so the only one potentially at risk here is ratepayers. So I'm trying to understand what risk Entergy has taken by doing this.
Well, and I don't mean to be stubborn, so please don't hear me that way as I say this. But again, Entergy Arkansas will have provided its customers a WAC return on these funds for the period between when this rider goes into effect and when the IRS determination is received for a position in that extreme circumstance that did not prevail. That's a real business cost.
Talk to me about the uncertainty, where the uncertainty comes from in taking this position. I don't know if that's a better question for you, Ms. Whaley, or for.
I'll take a run at it and let Ms. Whaley supplement. What's unique about the nuclear PTCs is the calculation of the gross receipts and how you do that. I believe, as was indicated in our filing and in Ms. Law's opening statement, we used MISO prices, specifically capacity and LMP prices, to do that. But the IRS could take a different view of how those gross receipts should be calculated. Could reduce the credits down to having no value. I'd defer to Ms. Whaley at this point.
I agree with everything stated by Mr. Lewis, and I'll just add that if the IRS were to come up with a different method for calculating gross receipts, whereby the gross receipts were lower under that method, then the reduction amount, the phase-out amount that the IRS has in place would have a bigger effect on the value of those credits, and they could potentially be phased down to zero much quicker than they are under the method that Entergy is currently using.
Yeah, so to be clear, under Section 45U, if the gross receipts don't exceed $25 per megawatt hour, the owner of the nuclear facility could receive a credit up to $15 per megawatt hour of generation sold.
That is correct, and I'll add clarity around the up to 15. So the $15 is in association with a prevailing wage and apprenticeship, adder, if you will. And I'll also say that, the facilities in question are receiving that benefit.
If the gross receipts calculation exceeds $25 per megawatt hour, a reduction provision associated with that tax credit kicks in, right? And reducing the credit to something below $15 per megawatt hour, as you indicated, potentially down to zero. Is that right?
I think that question would probably be better suited for me. It is correct that the $25 reduction amount does come into play. And if your LMP is $25 or greater, then the reduction amount will apply. And so you have to determine your revenues under, the LMP capacity first.
Well,
And
it's Entergy's position that it would be the LMP, but under
Correct.
45U, it's whether the gross receipts, right?
Right, but our definition of gross receipts is LMP and capacity. Just to help you understand how we determine the phase out is we would first determine the revenues under the LMP and capacity rate, and then we would calculate the base credit, which is $3. That would be our next step, which the $3 would be applied to the generation of the unit. And then after that, we would calculate the phase out or reduction amount. And the way we would do that is we would calculate the $25 amount times the generation, and that would be subtracted from, if you will, that LMP capacity rate, and the difference between those two would then have a 16% amount applied to it, which is also in the code, and then that would be the reduction amount, which reduces that base credit that I described, that $3 credit first, and then you apply that 5-time multiplier that is associated with the PWA.
Do you recall the amount Entergy recognized in its 10K for these nuclear PTCs for 2024?
I do. I don't recall it by heart, but I do have the pages from the 10K here.
Okay. Do you want to refer to those?
I would like to.
Based on a quick look, it appears Entergy is claiming the full amount of the PTC. Is that the $25? It's not expecting a reduction. That's what it's listed. That's what it's recognizing on the 10K.
Well, if we wanted to get into details about how that reduction amount works for us and our specific calculations, we would need to go HSPI. But I will state that the credits that are provided in the 10K are the gross credit amounts. But if we wanted to talk about more specifics around reduction and such, I think we might have to go HSPI.
Okay. We can come back to that. You mentioned before, but can you state for me again what the company is using to calculate gross receipts? Is it just the LMP price?
It's the LMP plus capacity.
Okay. Did the company give consideration to other forms of revenue and whether that should be included in gross receipts?
I'm only aware of LMP and capacity in terms of our gross receipts.
Yeah, it didn't include current retail revenue, right? Rate schedule revenue?
It does not.
Mr. Tate, it's nearing noon, and we all know at noon I'm going to go have lunch.
Well,
What point do you want? I want to
we
get
may
your
be
stopping
getting
point.
we may be getting back into HSPI stuff, so now might be a good time to break if you want to do that.
Sounds good. Ms. Land, Ms. Law, do you need to know any direction on your lunch work assignment?
I don't think so. I'm hoping I've got it.
Okay.
Thank you.
Thank you. Thank you all for this morning. And let's come back in at 1:15. Okay, 1:15. See you then. We'll be in recess. may be seated. We're back on the record. Ms. Law, what did you find out for me? If you'll go up and tell us what you know about Mississippi.
Yes, sir, about Mississippi. And I
Get a
was
little
also,
bit close to it. Yeah.
sure. And I was also able to get some clarification on Louisiana that I think might be helpful too for you. But for Mississippi, Mississippi filed at the end of February of 2026 as a part of their FRP. And it was just issued, an order was just issued in June of 2026. And then I also just wanted to clarify for Louisiana that there was an agreement filed with the LPSC staff in August of 25, but that agreement was not approved by the commission there until August 20th. And at that point, some of the agreements had already been executed. And so that did come after that decision had also been made.
Okay. Thank you.
Sorry, I
Yes,
walked
ma'am.
down too briefly. I also wanted to offer that in answer to Commissioner Tate's questions on some of the tax stuff, Ms. Whaley was able to run down a few of those items and has those answers for you. I think some of the answers are HSBI though, so I'll defer to you guys if you want to have her answer those now or perhaps answer it when we've cleared the room for another purpose.
Let me refresh memories. We entered order number 7 on docket 26-009U. That order said, in the interest of judicial economy and efficiency, and to prevent further delay into the investigation of this matter, Energy Arkansas LLC EAL is instructed that it must present a witness or witnesses for the July 9th, 2026 hearing who can completely testify to EAL compliance, Exhibit 2, and EAL's decision to sell its nuclear production tax credits, including any tax-related questions. This order was entered by Judge Frazier, one of our administrative law judges who does a very good job, and entered with the Secretary of the Commission on Karen Shook. We do not feel that this order has been complied with. It is not, too many questions have been asked today that there was no one here competent to give an answer. Too many, well, such and such and this and that. So I, as chairman, feel that it's appropriate that we recess this hearing. It will be subject to the recall of this chair of the chairman, and I would appreciate counsel for EL furnishing with names of individuals that can appear in person and testify and answer our questions. Am I clear? Do you have any questions? Any questions?
No, sir.
Ms. Law? Staff, any questions? Any questions? Any questions? No questions? Mr. DePippa?
No question.
No questions. Then we will be in recess, subject to the call of the chair at some time in the future. Thank you. We are dismissed. Been complied with. The first one was monetizing these tax credits, and now we come to a hearing in which we have directed you to bring us people that can testify. 2 orders. We will come back on the call of the chair. And let me say this. As a kid, I loved watching The Lone Ranger. Okay? I loved watching The Lone Ranger. Lone Ranger did many good things. But when the Lone Ranger went out on his own like EAL and didn't seek the advice and thoughts of Tonto, he invariably had problems. We seek to work with you. We seek to do what's best for the people of Arkansas, but you must consult this commission and seek its advice so that we're able to do that. Do you understand? That's a childhood lesson that we learn, and we must learn that in these proceedings, or we will have continued hearings and requests for the appropriate people to appear. Thank you again. We are dismissed.